Okay, great. Okay, well, good afternoon, everybody, and welcome to a double celebration. We are in this extraordinary year. We are observing Constitution Day, which actually occurred on September 17th, at the same time as we are observing the first Monday in October, which, as I'm sure you'll all know, is the traditional beginning of the new Supreme Court term. And we had called this program the Supreme Court in a Time of Crisis back when we planned the program. And a lot of new crises have happened since then, and it turns out that there's even more to talk about than we had initially anticipated. In terms of just number of crises surrounding the Supreme Court, you all know that due to the death of Ruth Bader Ginsburg, the court is starting its term with an empty seat, which is unusual to start with. Due to the pandemic, arguments will not be taking place in the majestic courtroom, and the court is going to be doing its business remotely, just like we do. In addition, the court had already planned a highly consequential docket of cases for this term. But in addition, the court has already been and undoubtedly will continue to be challenged to decide critical issues surrounding the presidential election, something Professor Wilfred Codrington will talk about, and also many types of cases about the impact of the pandemic itself. And then, in addition, in the background, we now have more drama than anybody had expected surrounding the confirmation of the nominee to fill Ruth Bader Ginsburg's seat. So we certainly have more than enough to talk about. So as I was saying, we're planning to keep our remarks quite brief to allow as much time as possible for questions and discussion. If you have any questions that you'd like us to discuss, at any time you can write your question into the Q&A. And then the three of us are going to speak, myself, Professor Ariza, and Professor Codrington, and then we will turn to people's questions and get to as much as we can. So I'm going to start by picking up where we left off at the end of our memorial tribute to Ruth Bader Ginsburg with the question of how the law might change in what I call the ruthless court. Justice Ginsburg has been the fifth vote in a range of highly important cases, including last term's DACA case about the Dreamers, the case that prevented the Trump administration from adding a citizenship question to the census, and a case that held the line on abortion restrictions, as well, of course, as in earlier cases, including even the Burgerfeld case on same-sex marriage. So there's a lot of reason to wonder how the changing composition of the court will affect the law in a lot of very important areas. But the area that I want to start with, which seems to me especially critical this year in the time of pandemic, and is also on the court's docket already, the court has already agreed to hear a case on this issue, is the area of the Affordable Care Act, also known as Obamacare. So Justice Ginsburg had been the fifth vote to preserve Obamacare against its many challenges. So the Affordable Care Act, as you may know, was enacted in 2010, and it is the most frequently challenged statute in American history. There have been over 2,000 challenges brought against it, with the first constitutional challenges filed moments after the law was enacted. The most important challenge the Supreme Court has heard to the Affordable Care Act was in 2012, the case of National Federation of Independent Business versus Sibelius. And the court upheld the ACA by a vote of 5-4, with the 5 including both Justice Ginsburg and Chief Justice Roberts. Now, you might have read that case in constitutional law, and if you've taken constitutional law, the issues are certainly familiar to you. The challengers claimed that there was no constitutional basis for the Congress to impose an individual mandate, which was the requirement that everyone either have minimally adequate health insurance or pay a penalty. A majority of justices, not including Justice Ginsburg, agreed with one important part of their argument, holding that the individual mandate could not be based on Congress's Commerce Clause power because, and somewhat formalistic thinking, because the statute did not regulate economic activity, but instead regulated inaction and required people to act. But Chief Justice Roberts switched his vote and voted with the 4 so-called liberals to uphold the individual mandate on the basis that it could be considered a tax, which Congress does have the power to impose, that people were being required to pay into a healthcare insurance system. Now, Congress has considered bills to repeal the ACA on 67 different occasions, and although the vote has been very close, they had not succeeded. But following the 2016 election, Congress did eliminate the penalty that was attached to the individual mandate. So Texas and 17 other states then challenged the constitutionality of the individual mandate once again on the ground that the language in the statute was still compelling activity, even though the individual mandate could no longer be viewed as a tax. Well, the Fifth Circuit agreed with that argument, which a lot of people had thought far-fetched until that point, and they ruled that the individual mandate was unconstitutional, and the Fifth Circuit remanded to the district court the question of whether the individual mandate was severable from the rest of the statute. Now, this is a lot more than a technical question, because if the individual mandate is not severable, the entire Affordable Care Act would be void and would just be struck down. So the Supreme Court has agreed to hear that case, evocatively named California versus Texas, with the argument scheduled 1 week after Election Day. And the Trump administration has asked the Supreme Court to invalidate the entire statute, to take the step that the Fifth Circuit did not take. Now, if there's no new appointment and if the justices continue to vote as anticipated, there would be a 4-4 split that would uphold the Fifth Circuit's ruling. And at that point, the future of the entire Affordable Care Act would be remanded to the district court. If there is a ninth justice who agrees with the more conservative justices, Alito, Gorsuch, Kavanaugh, and Thomas, it is possible that the court could accept the administration's argument and throw out the entire statute in the middle of a pandemic, which would cause 21 million people to lose their health insurance. So I think probably the best we can hope for at this point is that the court will take the actually more conservative approach in the natural meaning of that word and only invalidate the individual mandate provision, where some experts are saying that they think the ACA can hobble along without the individual mandate provision. But the future of the Affordable Care Act is very much up for grabs. So a week after the election, we will begin to see what the future of that area will be. I'll just briefly mention one of the other most closely watched areas, which is, of course, abortion. Now, it is perfectly possible that Roe v. Wade could be entirely overruled with the change in composition of the court, with an additional justice to agree with the 4 justices who have so far ruled against Roe v. Wade and all other abortion, and in favor of all other abortion restrictions. So to date, there have been about 1,100 abortion restrictions that the states have come up with. And some states recently have been setting up challenges to Roe v. Wade by enacting laws that flatly contradict Roe v. Wade. Laws about the gestational age, that, you can't have an abortion after your fetus is 12 weeks, or many other kinds of limitations that are clearly inconsistent with Roe v. Wade. So it's possible that one of those cases could reach the court, and the court would have to decide whether or not to preserve Roe v. Wade. So with an additional conservative justice, even Chief Justice Roberts' voice in favor of stare decisis would not matter. And what he did this past term in an interesting case called June Medical Services versus Russo, the court struck down by a 5-4 vote some abortion regulations that are generally known as TRAP provisions, targeted regulations against abortion providers, targeted restrictions on abortion providers. In this case, what Louisiana had provided was that any doctor performing an abortion was required to have admitting privileges at a local hospital. Now, the court not that many years before had struck down very similar regulations in Texas, but then Justice Kennedy, who had been the 5th vote in that case, Whole Women's Health versus Hellerstedt, retired and was replaced by Justice Kavanaugh. So Louisiana was not daunted by the fact that the Supreme Court had struck down the Texas regulations, but was hoping that the result would change. Well, in that case, Chief Justice Roberts decided to vote for stare decisis, and even though he had voted in dissent in Whole Women's Health versus Hellerstedt, switching his vote, he voted to strike down the Louisiana provisions. Now, as I was saying, if there is an additional justice on the court who agrees with the more conservative justices, his vote will no longer be the deciding vote. And therefore, I think that not only is Roe v. Wade up in the air, but the whole question of how many abortion restrictions the states will be allowed to have. And at this point, there are already at least 6 states that only have 1 clinic that performs abortions in the entire state. So even if Roe v. Wade is not overruled, there is a great likelihood that abortion will become unavailable as a practical matter to many people in the country. Now, I just want to comment more generally that Chief Justice Roberts has taken his role as Chief Justice as being, including maintaining the court's reputation for nonpartisanship and neutrality. You might recall that he chided President Trump for referring to a judge as an Obama judge. He said there's no such thing as Obama judges or Trump judges. We all just do the best we can to just be neutral and decide the law. And you may recall at his confirmation hearing, he said he's just an umpire calling the balls and strikes. The justices are apolitical. Well, unfortunately, it seems to be increasingly true that truly neutral umpires on the courts, the lower courts or the Supreme Court, are really a rarity. A justice's vote usually can be predicted by noting which party put them on the court. And so in addition, we've also seen the confirmation process become politicized to a hyper-partisan pitch. Ruth Bader Ginsburg was confirmed when she was a nominee for the court by a 96-3 vote. And her history at the ACLU, where she founded the Women's Rights Project, really barely caused a ripple in that confirmation process. And it is simply unimaginable that that same bipartisan spirit could prevail today. So the final thing that I want to comment is that precisely because of the hyperpartisanship surrounding the court, within the court, all around the court, it is also possible that if the Democrats win the presidency and the Senate, we may see some of the calls for Supreme Court reform that have been circulating taken quite seriously. The Democrats probably would be considering court packing, changes in term limits of the composition of the court, etc. So that's another very interesting issue to watch for the future, whether this Supreme Court term starting on the first Monday in October, whether the traditions of that court will seriously be up for debate. Thank you, and I'm going to turn the Zoom over to my colleague, Bill Ariza.
Good afternoon, and thank you all for coming to a discussion of a really exceptionally momentous time in our nation's history more generally, but in particular with regard to our legal history. We really are, as my colleague Professor Herman suggested, really on a precipice of a potential major change in in the court's direction, and it'll be fascinating and quite impactful on both your careers and your lives, frankly, as to how that change eventually plays out. So I'm sure there are lots of questions. So what I'm going to do is I'm going to confine my comments to a series of cases the court's decided in the last 5 years dealing with LGBT rights, and there is a lot more to talk about. Of course, we would all invite questions on anything, but I'll just confine, my comments to those. And so the story, of course, begins with a Burgerfeld versus Hodges decided in the now far-off time of 2015, where the court constitutionalized a right to same-sex marriage. 2 years after, that was, of course, a 5-4 decision. And it was Justice Kennedy, along with the 4 liberals, including Justice Ginsburg, who constituted the majority, with Chief Justice Roberts notably in the dissent. A couple of years after Obergefell, in a 2017 case called Pavon versus Smith, the court summarily, that is to say without full briefing and oral argument, the court summarily rejected an Arkansas law that essentially treated same-sex married couples differently than opposite married sex couples with regard to the rights of the non-birth parent when the non-birth parent's spouse gave birth. So in a conventional same-sex marriage, the woman gives birth, and that has certain implications. A conventional opposite sex marriage, a woman gives birth that has certain implications automatically as a matter of law for the paternal status of the woman's husband. That sort of automatic status was not accorded to 2 women, and because of that, they sued, and the court summarily rejected the Arkansas law as inconsistent with Obergefell, which insisted that same-sex marriage really means same-sex marriage, or equal marriage rights means equal marriage rights. That is to say, it means the full suite of rights that opposite-sex couples enjoy when they get married pursuant to a state's law. So that was Pavon. The year after, in a case called Masterpiece Cake Shop versus Colorado Civil Rights Commission, the court waded into an area that I think is really going to be a consistent issue over the next several years and maybe even beyond. And I'm actually going to defer a discussion of that because a case the court has on its current docket, a case called Fulton versus City of Philadelphia, sort of implicates the same basic issues that were implicated in Masterpiece Cake Shop. So we'll put Masterpiece off to the side just for a second. The last story in the sequence, at least the last decided one up to now, is a case called Bostock versus Clayton County. This was not a constitutional law case. This was instead a statutory interpretation case dealing with whether Title VII of the Civil Rights Act of 1964, which bans employment discrimination on the basis of other things, sex, whether that ban on sex discrimination in employment included protections both for lesbians and gays persons, but also for transgender people. And in a somewhat surprising to at least a number of people, 6-3 vote, with an opinion written, again, somewhat surprisingly to a number of people by Justice Gorsuch, the court concludes that yes, in fact, Title VII does include protections based on sexual orientation and transgender identity. So before we get to Masterpiece and then Fulton versus City of Philadelphia, I think what I'd like to do is maybe address the possibility of backsliding with regard to these decisions. And I think, frankly, and maybe I'm just being too overly optimistic here, I think, frankly, the likelihood of the court revisiting any of these decisions is low. I'll start with Burgerfeld, which is in some ways, of course, the in some ways the main event here. Look, lawyers generally, and judges in particular, value stability. That's of course why we have stare decisis, which is going to obviously play a role in this whole discussion about this backsliding potential. But they're also concerned about stability in the context of expectations. And I think for the court to overrule itself and to overrule a Burgerfeld and to deconstitutionalize the right to same-sex marriage would open up I mean, the term Pandora's box doesn't even begin to discuss the difficulties that would arise if the marital status of a whole lot of same-sex couples across the country suddenly were thrown into question. And you can imagine the sorts of fact patterns that would arise, everything from as fundamental as, do we still count as a married couple, to as mundane as what happens if we bought a piece of property between 2015 and 2020 or 2021, whenever the overruling would happen, and and we bought it as a married couple. What's the property status of that ownership status? So it's hard for me to believe that the court would overrule a Burgerfeld. Now, I've been wrong before. The court has surprised me before, both for the good and for the not so good. But I think I'm fairly confident that Obergefell is safe. I'm also fairly confident, to be frank, that Bostock and the Title VII interpretation, and of course with Obergefell I think comes Pavon, so that's not something that I think merits independent discussion. With regard to Bostock and Title VII, I'm also fairly confident that the court is not going to overrule itself, and for one particular reason. All these discussions, of all these potential overrulings deal with the question of stare decisis. Perhaps counterintuitively, stare decisis has an increased role to play in statutory cases as opposed to constitutional cases for reasons that, although counterintuitive, might start seeming to make sense once one starts thinking about it. In particular, it's really hard for Congress to overrule a constitutional decision with which it disagrees. You got to go through the Article 5 amendment process. On the other hand, it's really easy, or at least relatively easy, for Congress to overrule a statutory interpretation decision with which it disagrees. And for that reason, the court has always said that statutory stare decisis, in fact, plays a greater role than does constitutional stare decisis. Okay, so let's now finish up with a quick discussion of Fulton versus City of Philadelphia. Fulton, as well as the Masterpiece Cake Shop case from a couple of years ago, both deal with this very thorny problem of anti-discrimination protections on the one hand, usually, although not always, in the context of sexual orientation or transgender anti-discrimination rights, and religious freedom on the other. So you may remember Masterpiece Cake Shop. This is the case where the baker refused to provide a wedding cake for a same-sex couple claiming religious liberty rights, and he was brought up on charges under a state public accommodations non-discrimination law. Well, fast forward to the result. In a very narrow decision, the court decides that the state Civil Rights Commission's decision to get rid to convict this person of a violation of the law was based on animus against the individual's religious beliefs, which we can discuss the details of that in the Q&A if people want to do that. Fast forward now to the last thing I'll say, which is Fulton versus City of Philadelphia. This deals with Catholic social services, this provision of foster care services in conjunction with the City of Philadelphia. Philadelphia insists that CSS not discriminate based on sexual orientation when making decisions to refer parents or would-be foster parents to the city for placement of a foster child. You can imagine CSS claims religious beliefs. It believes that it really should not have to refer couples that it believes, as a matter of its religious dogma, are unfit as parents or as a family unit. You can also understand the City of Philadelphia's concern, on the other hand, to ensure that these services are provided on a non-discriminatory basis. My time is more than up, so I think maybe I'll leave, because I don't have unfortunately, I cannot give you a 10-second answer as to how to resolve this problem. Maybe I'll just leave it at that for that reason. And if people want to explore this really fundamental tension between religious free exercise rights on the one hand and anti-discrimination rights under statute on the other, maybe we can defer that to the student Q&A. Thanks.
Let me just say, before Professor Codrington begins, I just want to be sure that everybody knows, Professor Ariza referred to posting questions. The Q&A box is open for you, so if you want to post any questions now, we won't start answering until after Professor Codrington has spoken, but you know, don't feel you need to wait.
Great, thank you. Thank you, Professors Herman and Ariza. I was really looking forward to that 10-second answer, so I'll just have to wait for the Q&A as well, I guess. Unfortunately, my talk is probably going to prompt more questions as well, and I won't be able to give you the answers in 10 seconds, so we'll look forward to that discussion. So thank you. I want to really just talk about two cases in particular, and I'm going to speak about elections, which are very fraught these days, obviously. I want to look back and talk about one, and then sort of look to the present and talk about another. So looking back, I want to talk at the end of the last term, the Supreme Court handed down a pair of decisions, the Chiafalo and Baca cases, the so-called faithless electors cases. So in 2016, two states and some electors sort of had this harebrained scheme to vote against Hillary Clinton and persuade electors to vote against Donald Trump to throw the question to the House of Representatives for a contingent election. Totally crazy scheme. But the question presented here was whether the Article 2 of the Constitution and the 12th Amendment would, the provisions that govern the Electoral College and the selection of the president, whether they empowered states to impose sanctions on electors for noncompliance with state-imposed pledges to support the party's candidate or for being faithless. So the court had in the 1950s decided that it was lawful for states to require electors to take these pledges to support their party's nominee, but they left over the question whether or not those pledges could be enforced. And in Chiafalo and Baca, so the faithless electors cases last year, the court said the pledges are indeed enforceable. So states could impose monetary fines, they could remove and replace a defiant elector, and they could even impose start criminal proceedings. Importantly, in the constitutional text on this question is really non-existent. And indeed, the text regarding most of the provisions governing the Electoral College are pretty scant. So in terms of an original understanding and the design of the Electoral College, the weight of the evidence actually, I believe, supported the opposite conclusion. That is to say that electors in the Electoral College were designed that they were to be the intermediaries between the people in the process of selecting the president. They were supposed to be, quote, the fittest men for afforded some independent judgment for choosing the president among the best candidates. However, over time, history sort of went the other way. So electors largely became party insiders and lackeys and even yes men. So they more or less made the job almost pro forma of just supporting their candidate's nominee or their party's nominee. So the court was dealing here with early history and the design of the Electoral College, with the changes of the Electoral College over time, and ultimately accepted the latter one as the constitutional one. It is really a fun opinion to read. It's filled with cultural references, including to Veep and Hamilton and all this other stuff. And ultimately, in my view, the decision was an appeal to pragmatism. The court acknowledged that the right to vote for president is a fundamental one in nature, and that irrespective of textual ambiguities in the Constitution and its original understanding, it would be unfair to deprive Americans their role in selecting the nation's leader. So even more, and while Justice Kagan's opinion did not state so explicitly, I think it surely signaled that the electors exercising independent judgment, especially now, would inject the potential for political instability. This sort of chaos view underlying the decision that it would be problematic during this particular election where you have a pandemic occurring and voting is already sort of disrupted. It would be problematic to allow a few defiant electors to kind of decide the outcome of a close election. I don't make predictions too often, but I kind of did expect this decision. There are no real surprise there. The court just sort of affirmed another measure that states have power over elections in very much in line with what they do in the overall election scheme, which is to say they have primary jurisdiction over elections in the administration in this patchwork federal democracy, and they can bind their electors. And so right now, what we're left through, the implications of this are 33 states and the District of Columbia have some sort of faithless electors laws on case. Notably, however, there are quite a few states that don't have faithless electors case laws on their books, or they have laws that don't impose penalties on faithless electors. And this includes important swing states like Florida, Ohio, New Hampshire, and Wisconsin. So the opportunity for defection does remain. So that's the faithless electors cases. And I want to talk sort of looking like in the near future, a case regarding Arizona and the Voting Rights Act. And this came up very, very recently, actually. Last week, the Supreme Court added this to the docket. It's a case called Arizona Republican Party versus the Democratic National Committee, and it's consolidated with another case. And so these cases are being appealed from the Ninth Circuit, and they're really going to test what remains of the Voting Rights Act. They relate to Section 2 of the Act, which has national application, and it prohibits any policy or standard or practice or procedure that results in the denial or abridgment of a person's right to vote on account of race and or language minority status. So the Arizona law at issue here went into effect in 2016, and it relates to two specific provisions. One is out of precinct voting, and the other is a third-party collection and delivery of ballots. So Arizona's out of precinct provision, the state wholly discards rather than counting at all or partially the ballots that are cast in the wrong precinct. According to its ballot collection provision, with limited exceptions, the state criminalizes third parties who collect and deliver another person's early ballot. So just a quick note, the idea behind the out of precinct policy, sorry, OOP we'll call it for short because it keeps tying me up. The OOP, the idea is that when you're registered and you go to the polls to vote, there's a number of reasons why your name might not show up on the rolls there. One such reason is that you're at the wrong place. And, but under any circumstance, you're eligible to cast a provisional ballot. Under Arizona law, though, if that provisional ballot is cast because you are at the wrong place, well, it's not counted. And it's not counted whether your vote was for president. You are still eligible to vote for president, which is a statewide measure, or a Senate, or any statewide office. They're just all rejected. And Arizona has been deemed an outlier among other states for its rejection of out of precinct ballots. So from a national perspective, it's an outlier. Second, when you compare white voters to racial minorities, Arizona is also problematic because this policy impacts African Americans at 37% higher rates, Native Americans at 47% higher rates, and Latinos and the Hispanic community at 123% higher rates. So there's a disproportionate impact here, undoubtedly, which is why the case was filed. And then the third problem are the factors that lead to out of precinct voting, which is they also impact these communities at higher rates. And that's sort of frequent moving of polling places, confusing placement of these places, and high rates of residential mobility. So if you were to consider the instability of polling places, for example, 30% less stable for African Americans and Latino than white people, for example. For you Harry Potter fans out there, an appellate judge said that the moving of polling locations was equivalent to the changing stairway in the Hogwarts. You just would never know where it's going to lead. As for the confusion of polling places, well, we also know that a lot of Native Americans living, particularly on tribal lands, they don't have addresses that correspond to homes like you and I do. So often they're assigned a precinct according to guesswork. So overall, we look at this, and what happens is 25% of the people who are actually casting their ballots out of precinct are actually going to a place that's closer than where their assigned precinct is. So the appeal court found that the district court erred in a number of ways, and it basically, this amounts to an abridgment or denial. And then just quickly, with respect to the ballot collection provision, the problem here is that the ballot collection provision is to encourage people to vote, and these are people who find it difficult to get to the polls. So this is your elderly, your wage workers without time off, childcare duties, without adequate transportation, et cetera, and those people who don't have reliable local mail facilities. So again, this is your Native Americans, for example. Just 18% of them have registered home mail service, and many living on sovereign lands have to travel 45 minutes to 2 hours to actually just get to a mailbox. So it is, again, minority communities that are disproportionately taking advantage of the service, and some organizations are pretty successful in terms of returning the ballots for these minority communities. And the sort of trick here, the other step, is that the appeals court found that there was not only a racial result, a racially discriminatory result, there was also intent. So there were two reasons why they found this in particular. One was there was a video that the court called racially tinged. I hate the word racially tinged, but you can imagine with the video included, it was a Hispanic-looking man who, like the narrator said, he wasn't sure if he was an illegal alien or he was a dreamer or a citizen, but whatever he was a thug, and he was stuffing ballot boxes and going to vote parties where people were giving sort of uncasted ballots and they were filling out. So this had particular sway in the debate for passing the law, and that's one reason why the district court found that there was racially discriminatory intent. The court also found that the laws that led to this happened in a progression. There were three very specific laws that sort of got to the point where they outlawed the collection and delivery of ballots. So the first one was not pre-cleared under Section 5 when that was actually in effect. Rest in peace, Section 5 of the Voting Rights Act. The second one was that it was passed, but when legislators were faced with a referendum, they repealed it. And the third one is the one at issue here. So progressively, each got more strict, and the last one being the one that criminalized the act altogether. That's kind of where we are with this. It was just added to the docket, so it probably will not be heard until after the election. But there is a circuit split on the question, the broader question, and that's what we're going to be faced to deal with.
So, Professor Ariza, I think the first question is for you.
Absolutely, and it's a great. Can I assume, Professor Herman, that everyone sees the question? Or should I repeat
I don't
it?
think you can. I'm not sure if everyone can. Then people can't talk to us. So why don't you just read the question before you answer it?
Absolutely. Yeah, sure. So, anonymous attendee asks, Thomas and Alito just called into question Burgerfeld and its, quote, ruinous consequences for religious liberty, unquote. If the court looks to stare decisis, why call into question this precedent that would affect the lives of so many, especially on a decision not to hear a case? And that is a really great question. So let me just have just a couple of thoughts in response. Number one, for everyone's benefit, Thomas and Alito, of course, dissented in Burgerfeld. What what Thomas did is not completely clear to my memory, but I know that Justice Alito didn't just join other dissents. He wrote his own dissent where, in fact, he focused quite heavily on the religious liberty question. So it does not surprise me that he in particular would say the kind of thing that he was saying in this dissent from a denial of cert, it sounds like, or maybe even a concurrence, I'm not sure, but a decision not to hear a case, as the questioner noted. So those justices were concerned about the religious liberty question way back in 2015. The thing about writing that sort of thing, that statement, in a decision respecting a denial of cert, whether a concurrence in the denial or a dissent in the denial, is that it is those separate opinions in that kind of decision, to not hear a case, are really great opportunities to signal your particular views about a particular issue without actually having to go on record as actually coming down one way or another. This is really a nice way, I think, to signal litigants in particular that they would be receptive to certain arguments. I think also it's a way of signaling to their colleagues that they would be receptive to certain arguments. And in this case, I think the argument that they're trying to signal receptivity to, again, and I'll just restate my own kind of prognostication here. I really don't think it's going to presage a full bore attempt to overrule Burgerfeld, although they may say that in any opinion that might collaterally raise the question. I think instead, what they're signaling is a real desire to push the court toward a more religious liberty favorable position, even at the expense of anti-discrimination principles. Whether those principles are statutory, like in Bostock, or in Burgerfeld, whether they're constitutional, I think it's an attempt to push the court in the direction of more of a focus on religious liberty. And the last thing I'll say, so that's kind of that's why I suspect they wrote what they did. And the last thing I'll say, and I'll just kind of throw this out for students to think about this, or even my colleagues. I think it's a fascinating question, the justices signaling via these separate opinions regarding denials of cert. And I wonder whether there has been more of that over the last 10 or 15 or 20 years than before. And I think that's actually grist for a really interesting study, if anyone cares to take the time or is looking for a law review note.
Well, since you can't see what's in the Q&A, I'm thinking that actually if people want to ask questions in the chat, I think everybody can see the chat. So if you want to know whether somebody else has asked your question, that might be as good a way to do it. But we have 2 more questions in the Q&A, which are overlapping. So I'm going to read them both, and then Professor Codrington, if you want to take the first stab at the combination question, happy to have that happen. So Matthew Boyd asks, assuming ACB is appointed and the Democrats take the Senate and the presidency, do the panelists feel that jurisdiction stripping is a better method of getting SCOTUS under control, or is expanding the number of seats on the court the more appropriate method of preserving its legitimacy? Perhaps a combination of the two might be best. Okay, I'm just told, thank you, Megan, that the attendees can't see the chat either. I can't see it, so I was informed by a student that they can't see the questions, and I now also know they can't see the chat, so it doesn't matter. So go ahead and post things either place, and we will see them. But here's the second question, Wilfred, that overlaps. Chris Gibbons says, what are your thoughts on the idea of term limits for the justices, a similar question, or adding seats to the court to offset a conservative bias? Should Biden win, are these likely? What would prevent a future Republican Congress or president from doing the same or undoing these changes if they were enacted? Okay, so 2 overlapping questions about Supreme Court reform and the path ahead. So what are your thoughts?
Sure, yeah, I'm sorry. I guess you need to separate some of the questions because they require different things. So if we're talking about changing life tenure or putting in term limits, we're talking about Constitution Amendment territory, and that is difficult. That's a hard threshold to meet. You need supermajorities in both Congress and the states to actually affect that. So that would be very difficult. Personally, I'd like to see something like that specifically for the Supreme Court, just because I do believe that once you actually put on some sort of term limits for some reason, some people have talked about 18-year term limits. You have 9 justices. You appoint a new justice every 2 years, so every president gets 2 at regular intervals. That might actually dampen down some of the partisan warfare about confirmation. It might also slow down some of the sort of penchant for justices to sort of time their departure from the bench. So I tend to be in favor of that, and I also think that that tends to give the court more of an air of legitimacy, which I think is much more important than in terms of the political branches. In terms of adding justice, so that's not necessarily, you don't need a constitutional amendment for that because that's statutorily set, the number of justices in the Supreme Court. This was famously tried, or at least proposed, with FDR's sort of packing of the court that was sort of shot down quickly. He ultimately ended up getting the justices he wanted because he was in the office for 4 terms, or at least elected for 4 terms. So he basically appointed all but 1, I believe, of the justices in his time. But is that legitimate? So there's a couple ways to think about that. You might think about it from the perspective that if Amy Coney Barrett is appointed, you would have a majority of the justices appointed by a president who did not win the majority of the popular vote. That is a question of legitimacy, right? We've had 2 elections recently where presidents were elected by the Electoral College, but not by the majority. And some raise concerns with that, right? So you might think about it that way. You might think about it in terms of actual just administration. The justices hear far fewer cases than they heard in history. And that might be partly due to the number of cases the number of cases each justice can hear. So there might be a legitimate reason to add justices just to deal with the administration of justices to the court. And then you have just a general question about whether or not it would be right for Democrats to do so in the instance that they actually won the Senate and the presidency to make up for the ideological divide. That is a harder question, but I think undoubtedly it would prompt a sort of race to the bottom, I guess. Inevitably, I think that Republicans would endeavor to do the same thing once they got it. So you really do have to be cautious about that role or that route and sort of your reasonings for going that way. I'll stop there, and Professor Herman, if you want to pick up and talk about things that I might not have caught.
So Bill, do you want to go first? You were nodding. It looked like you had things you wanted to add.
No, I'm sorry. I was nodding because I was agreeing with Professor Codrington. I'll just say one really quick thing, and then I'll give you, Susan, the lion's share of any more time on this. There has been chatter among professors about whether, in fact, term limits requires a constitutional amendment. I happen to agree with Professor Codrington. I think it does. But in case anyone's curious, I think the chatter has sort of maybe centered on 2 potential ideas, both highly speculative. One is the idea that one can be, a Supreme Court justice could conceivably kind of be headed down to, let's say, a circuit court. And that would sort of not necessarily impair the idea of life tenure. If you're curious, that conversation has centered on the question of what was the justice appointed to do? Appointed to be on the Supreme Court, in which this rotation downstairs would be a change in the office, and therefore, a different office, and therefore the life tenure provision would be violated? Or is it simply, are you simply appointed to be an Article III judge? And I think the doubters have the better of that argument. The other one, and this is, I think more a matter of just history and the historical meaning of words. Article 3 says good behavior. It doesn't say for life. Now, it is quite likely, I suspect, although I do not know this, that good behavior in 1787 was thought to essentially mean for life. But to the extent it's not, at least there would be an opening there to cut back on life tenure. And I'll just associate myself with everything else that Professor Codrington said. In particular, the problem of if you open this box, it's not like the other side can't reach in the box also when it's their turn to be in power. And I think that goes for jurisdiction stripping and it goes for court packing.
Oh, thank you both. Those are both great sets of remarks to build on. I guess I also want to start by disaggregating things, as Professor Codrington was suggesting, because a number of the proposals, as both of you were just saying, do seem to require constitutional amendments. There are some arguments that maybe you can mess around with the term limits and the composition of the Supreme Court without requiring a constitutional amendment. I think that probably the better view is that a constitutional amendment is required to do those things. I agree with that. I think Article 3 says Supreme Court justices, there shall be one Supreme Court, and Supreme Court justices are supposed to have life tenure. But I think there are two killer facts here. Number one is that any constitutional amendment at this point that we proposed to try to ameliorate the conservative power on the Supreme Court is not going to pass. Because the majority of the states, that you require a supermajority of the states. So it's the same as the Electoral College. The states that are gaining more power than is their due are not going to vote to give away that power. As someone I know once said, you're not going to get turkeys to vote for Thanksgiving. So, it's not going to pass. So, the idea of putting all of our, eggs into that basket is not going to happen. Plus, even if it passed, who is it who will decide whether or not it would require, if you do this as not a constitutional amendment, I'm saying, if we just did that as a law and hoped that it would not require a constitutional amendment, who is it at the end of the road that gets to decide whether or not that law would be unconstitutional? It would be this very Supreme Court. So I think that the whole idea of changing the composition of the court in the near future is not something that's likely to happen, because I think you can't do it by constitutional amendment because it's not going to happen. And if you don't do it by constitutional amendment, I think it's highly unlikely that if there's an argument that you should have, that the Supreme Court would strike down any law like that. Now, as you were both saying, there are things that can be done, including the jurisdiction stripping. My general inclination is to agree with the kinds of arguments of, as our colleague Joe Crayer used to say, what goes around comes around. And so if we do this now, then they come back and you end up with a 47-justice Supreme Court, and the Supreme Court isn't allowed to decide anything, which sometimes we like and sometimes we don't like. But I think all of that is within the context of we are experiencing a kind of a perfect storm right now. Professor Codrington was just saying we're in a remarkable era of minority control, where a minority of the country has controlled a majority and perhaps supermajority of justices on the Supreme Court, as well as the presidency, as well as the Senate. And this is, the Supreme Court was supposed to be a kind of a counter-majoritarian check, but not to this extent. So the minority control is truly remarkable, plus the hyper-partisanship that we have at this point. Somebody I know just, people keep talking about, are we going to have a civil war? And this very smart guy who I know was just saying that we are having a civil war. It's like a Cold War. It's a cold civil war. And as Professor Ariza was saying, if both sides keep ramping up, where does it end? Now, I will tell you, because I think I can tell you this, that I was just chairing an ACLU board meeting over the weekend, and we were talking about getting the process started to think about, would we weigh in on any of these proposals? So my general inclination is to prefer the long-term neutral principles to any short-term result-oriented action. But the combination of the minority control and the hyper-partisanship makes it really hard to see any way out. When FDR had proposed court packing, the ACLU has been around a long time, so we looked back at our records and we discovered that the board of directors had a meeting and decided quite intentionally not to take a position. That that we didn't want to weigh in on the procedures, that it would feel too result oriented. So I don't know where we'll end up this time. Stay tuned. We have people working very rapidly on figuring that out. But I think it is a real conundrum because we are in the middle of a civil war and extraordinary minority control. And I don't know, it's a very difficult question in many different ways of how you balance those two phenomena. There was also a procedural question that was asked, if one of you want to take this, from anonymous attendee, which says, what happens if a justice is confirmed midway through the term? Does the justice not participate in a case where they missed oral argument? Either of you want to take that?
Yes, that's my understanding, is that if they weren't there for the oral argument, then they're deemed to have not participated in the case. I don't know whether that's just one of these norms that we keep hearing about being violated every day, or whether that's somewhere in the Supreme Court rules. But I think that's the general state of whatever we call it, a norm or a rule.
Yeah, that's my recollection. I would want to check, more formally to really be able to answer. But I certainly recall a number of cases that had to be re-argued because the court split 4-4, and then there was a new justice.
I think we're all
there are
on
a
the
number of
same
examples.
Yeah.
I was going to say there are a number of examples where if you look, you see that a particular justice didn't participate in the case exactly because that justice had not yet been confirmed. Like Justice Kennedy didn't participate in Morrison v. Olson in 1988 or 9, whenever it was, because presumably because he didn't hear oral argument. I don't know that for an empirical fact, but that must be why he didn't participate.
Great. So we have another question from Christopher Kendi to anybody. Does anyone have an opinion on the withdrawn opinion from ACB on D&O insurance on the Seventh Circuit, which I read about in Law 360 this morning? Does that bode well or ill? Thanks. I will claim total ignorance on my part. I don't know about that opinion at all. So
I don't either.
Okay.
Yeah,
I think the answer, Chris, is no, we don't have an opinion. We would have to know more in order to form an opinion. No. The answer is no, we do not. We have a clear answer. No, we do not have opinions, informed or otherwise. So I have a question that I had actually warned Professor Codrington that I might ask, because this to me feels very urgent. So you were describing, of course, the Electoral College and the problem that we have with minority rule. And as some of our attendees will know, there has been a workaround, the National Popular Vote Act, which would allow a majority of, if states got together, I'm going to let you describe that. But there have been arguments that even if the states could pass the National Popular Vote Act, that there have been arguments that it's unconstitutional. So is the workaround around the Electoral College, which we can't get rid of by constitutional amendment because turkeys don't vote for Thanksgiving, is the workaround doomed because the Supreme Court will hold it unconstitutional? So what do you think? Could you describe to people what that is in case they don't know, and then tell us what you think?
Sure. So the National Popular Vote Compact stems from the same provision I was talking about when we were talking about the Electoral College, the faithless electors cases, which is the provision of the Constitution that gives the legislators the right to appoint electors. So under the National Popular Vote Compact, let me say it this way. Currently, all states use some form of popular election to determine who their electors are. So 48 states and DC choose whoever, the slate of electors for whoever wins the majority vote in their state. 2 states break that up by district, congressional district, but still by popular vote in the state. The idea behind the National Popular Vote Compact is that instead of states awarding the slate of electors to whoever wins the popular vote in their state, they would award it to whoever wins the popular vote nationally. So irrespective of whether you win the national popular vote in California, for example, California would give its electoral votes to whoever won the nationwide popular vote. The other part of the idea is so that nobody's unilaterally disarming. This only goes into effect when you get 270 worth of electors, states on board. So that's obviously the amount you need to elect a president. There are some questions about the constitutionality of this. So I'd first like to say that there's questions about the sort of the politics of this, and that's whether or not you can get 270 states worth of electors on board. And so right now what you have are, I believe it's 196 electoral votes on board, and they come from mostly blue states. So these are Democratic states who are all in accord with the idea of the national popular vote, but you still have 70 some odd state electoral votes you need to make up. Right now, the only non-full blue state, so we'll call it a purple state, that signed up for this is Colorado. And Colorado is, in fact, they have this question on their referendum this November. So the state of Colorado, their legislators signed up for the National Popular Vote Compact. Now they're asking their voters whether or not they want to rescind their state's participation in this. So that, I think, is going to be clarifying, at least to some extent, to say, is there a way forward through purple states or some other sort of coalition to get to the rest of the number of electoral votes that you need to actually get to the 270 to go into effect. And then when you get there, let's say you do get to 270 votes worth of states, then you have the question of whether it's constitutional. And I like to think about this, I guess, in two buckets. The first bucket being, is it constitutional sort of under the Compact Clause? And the other one being, is this constitutional under Article 5, which is the amending provision? I'll answer the second one because I think that one's the easier one, just straight up. The idea is that the amendment provision only allows amendments through the formal means that we talked about, the supermajority of Congress in the states or through a convention of states. And this is an amendment in another name. So in effect, it sort of, it undermines Article 5, or it sort of is conflicting with that. I just think that's sort of laughable. This is obviously not an amendment, because if you have the national popular vote in effect, you still need the Electoral College for it to go effect, because it's based on the electoral votes, right? So you're not amending the Constitution, you're not striking out the Electoral College. This is just a way that to sort of use the system to kind of get the outcome that you actually are looking for. As for the Compact Clause, that one's trickier. I think that's definitely going to be argued. And the idea is the Compact Clause requires that compacts, interstate compacts, so between states, if they're to have agreement, Congress has to give the okay for them to do that. There's one part of this which is just to say Congress can give the okay, and this would be fine, and Congress can actually do that before the compact goes into effect or afterwards. But there's also a question of whether Congress needs to actually give its okay, and that's a question that goes to what types of compacts actually need Congress's okay. There's a whole line of cases that kind of goes to this. I tend to believe that the cases say no, because this is not the type of case that would give any one state power over the rest of the country. And just this is a question that's sort of nuanced and sort of about the design of the Electoral College, but some argue that it would. So it is possible that if this were to go to effect and Congress did not give it its okay, it would end up at the Supreme Court and they would decide. And if they were to decide, I would venture to guess, typically I'm not a betting person, but on voting cases, it tends to go along ideological lines.
Yeah, not surprising. So we have about a minute and a half left. Does anybody have any final thoughts that you'd like to share? Well then, okay, I'll share a final thought, which is somebody just sent me a photo of a yard sign that was seen someplace in Massachusetts. That was the Shepherd Ferry version of Ruth Bader Ginsburg. You can all imagine the red and the blue, you know, they're enormous Ruth Bader Ginsburg and Shepherd Ferry style. And on it, it said in enormous letters, vote and tell them Ruth sent you. So, of course, none of us are telling you who to vote for, but everybody vote. Make sure you know how you're voting, where you're voting, how it's going to happen. So thank you all for joining us for First Monday in October and for Constitution Day. Been a pleasure.
This has been great.
Thank you.